waiting children, miserable faces of helpless patients and their attendants, and foul stenches are some of the realities that meet you in many government health institutions. The situation is worsened by difficulties in accessing prescribed medicines. Medicines are sometimes not available in government health facilities, yet in drug shops and other private outlets, they are expensive and unaffordable to the majority of Ugandans who have no choice but to wait at home to heal naturally or die. The finger pointing aside, Ugandans should brace for even tougher times in accessing essential medicines should the Industrial Property Bill and the Anti-Counterfeit Bill currently under debate in Parliament are passed into law in their present form. Uganda is a signatory to the Trade-Related Intellectual Property Rights Agreement, better known as the TRIPS Agreement, of the World Trade Organization, and is currently overhauling its commercial justice legal system to align it with the TRIPS Agreement as required by the World Trade Organization. The Industrial Property Bill 2009 is one of the laws in the making. Introduced into the 8th Parliament for enactment into law, the bill is one of those gathering dust on the shelves of Parliament after the expiration of the 8th Parliament. The bill is currently before the Legal and Parliamentary Committee for consultation with the stakeholders.
We have 3 intellectual property bills in our committee. We think that starting early next month, we should be able to have public hearings, and hopefully by end September, mid October, we should be able to get these bills out of our committee and out of Parliament.
Almost 90% of drugs in Uganda are imports, of which most are generic versions. A generic drug is a drug product that is comparable to brand-listed drug product in dosage form, strength, route of administration, quality and performance characteristics, and intended use. According to Mr. Dennis Kibira from Helps Uganda, this will greatly undermine the population's accessibility to cheap, effective drugs, especially the antiretroviral therapy (ART), at a time when government is fighting hard to enroll HIV/AIDS patients to the treatment.
We need a law in place which will enable us to utilize these flexibilities to have these medicines, whether they are locally made or imported.
Once passed into law, it will attract multinational drug-making giants like Pfizer, GlaxoSmithKline, among others, that invest in research to stop local pharmaceutical companies that produce cheaper generic drugs.
The law is extremely important, but the major point of contention has always been overemphasis on protection and forgetting the other purpose of intellectual property, of ensuring that the public actually accesses what has been innovated. The law is supposed to serve 2 purposes. It is supposed to ensure that people that have innovated are protected, but it also must provide for provisions where these innovations that have been developed actually are accessed by the public.
As currently drafted, the bill does not make full and maximum use of the TRIPS flexibilities, and as such impedes access to medicines by Ugandans.
What is commonly referred to as a parallel importation provision. This allows the importation of drugs which would be more expensive in a country like Uganda, but when Uganda gets the same drugs from Kenya, it would not necessarily be an infringement on the manufacturer's rights under the Patent Act. So that provision is usually called the parallel importation provision. It's extremely important to be recognized. There is what they call the BOLA provision. Under the BOLA provision, it's important that you encourage research into a particular drug without infringing the patent rights of the person who innovated the drug. Because in the initial intellectual property, the moment you do research into a drug that is protected, you'd be infringing on someone's patent before it expires. Now, the BOLA provisions allows for research to be done even when the patent is actually still existing. This is extremely advantageous, such that when the patent immediately expires, instead of doing further research, you immediately bring the drug onto the market.
Uganda is part of the East African community, and as such, the laws made in Arusha, the headquarters of the community, have a direct implication on those passed in the Ugandan Parliament. There is a need to harmonize these initiatives with the developments at the national level.
Compare the current bill of Uganda, the Industrial Properties Bill, and for instance Zanzibar. Zanzibar has much better provisions like ours. For instance, before you grant a patent in the Zanzibar Act, you must actually prove that the person that you're granting a patent has innovated something that is beyond the normal scientist. So in that way, you ensure that patents are given to actual innovations that are beyond flimsy innovations. This is not yet the case in the Ugandan Act. So we need to see that Ugandan Act actually borrows best practices from other laws in the region.
Affordable generic medicines could become inaccessible unless the country protects them by incorporating the TRIPS flexibilities into the laws that are currently being revised.